Thank you. Okay, we're ready. Radio Walker, Roberts, and Coleman.
Yes.
This is case number 1658-603. People of the State of Michigan versus Defendant 1, Gregory Walker, Defendant 2, Lillian Roberts, and Defendant 3, Ernest Coleman. Defendant 1 is charged with count 1, homicide, murder, first degree, premeditated. Count 2, homicide, felony murder. Count 3, kidnapping. Count 4, torture. Count 5, unlawful imprisonment. Count 6, weapons, felony firearms. Count 7, weapons, firearms, possession by felon. Defendant 1 is a habitual offender, fourth offense notice. Defendant 2 is charged with count 2, homicide, felony murder. Count 3, kidnapping. Count 4, torture. Count 5, unlawful imprisonment. Count 6, weapons, felony firearms. Count 8, weapons, firearms, possession by a felon. Also, defendant 2 is a habitual offender, fourth offense notice. Defendant 3 is charged with count 2, homicide, felony murder. Count 4, torture. Count 5, unlawful imprisonment. Count 6, weapons, felony firearms. Count 9, weapons, firearms, possession by felon. Also, defendant 3 is a habitual offender, third offense notice. Also, case number 1658-561. People of the State of Michigan versus Defendant Ernest Coleman. The defendant is charged with count 1, kidnapping. All defendants are present for examination.
Okay, your appearance.
Good afternoon, Your Honor. Ashley Chaffone on behalf of the people.
Thank you.
Brian Stormer for the people.
Thank you.
Thank you. Good afternoon, Your Honor. Christopher Kessel on behalf of Mr. Walker.
Thank you, and good afternoon, Mr. Walker.
Lillian Roberts on behalf of Ms. Roberts, who's sitting in front of me. Good afternoon, sir.
Thank you. Good afternoon, Ms. Roberts.
Good afternoon.
Your Honor, Craig Daly on behalf of Ernest Coleman.
Thank you, and good afternoon, Mr. Coleman.
Good afternoon.
Okay, today is the date for the continued examination. I do know that in several sidebars on this morning, that the people indicated that they have only one witness that they'd like to call at this time.
Yes,
Is that correct?
Yes.
And I believe that there is an issue with respect to this witness, Tamara Grady.
Yes, Judge. At sidebar this morning, defense counsel for Mr. Coleman had expressed a concern about her testimony that it could lead to incriminating statements. And so this court had appointed Ms. Slomsky to represent Tamara Grady. I then had a petition and application for an order granting immunity signed by one of my supervisors, Robert Stevens, and we're asking the court to sign an order granting immunity to the witness, Ms. Grady. Ms. Slomsky's had a chance to review both those documents and go over them with her client. She tells me that her client's ready to proceed and testify.
Okay, thank you. Your appearance for the record.
Patricia Slomsky, Your Honor, appearing on behalf of Tamara Grady.
Thank you. And just so that the record is clear, the court did, when it was brought to my attention that there may be some issue with respect to Ms. Grady, that the court did ask for the appointment of counsel to Ms. Grady to properly advise her. And so Ms. Slomsky was the person who came down to speak with and meet with Ms. Grady. And so your client is ready to proceed. Is that correct?
Yes, Your Honor. I think the prosecutor has accurately reflected the agreement of use of immunity in this case. I've had extensive discussions with Ms. Grady in this matter, explained what that order means, and she tells me she wished to testify notwithstanding that. But at this point, she indicates that she does, in fact, wish proper testimony in this case.
Okay, thank you. Mr. Surma, you may approach with the order. Is there anything that any of the defense attorneys would like to add to the record at this time before that final witness is called?
Not on behalf of Mr. Walker, Judge. Thank you.
I'm sorry, Judge.
Anything you'd like to add to the record
Oh,
before
no, I'm sorry, no, Judge.
Thank you, Mr. Daly.
No, thank you.
Okay, thank you. I am going to sign the order. And with that, the people may call their witness. Sequestration order is in place. There was an exception granted for the officer in charge in this matter. And are there any individuals that need to be excused from the courtroom at this time on behalf of the people?
No.
And on behalf of any of the defendants?
None for Mr. Walker, Judge.
None for Ms. Roberts, Judge.
No, Judge.
No.
Okay, thank you. All right, you may proceed with your witness.
Just make sure she's got your name.
Tamara Grady. Tamara
Grady.
Grady.
Thank you.
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
So help I God.
You may be seated.
Okay, you may proceed.
Thank you, Judge. Good afternoon, ma'am.
Good afternoon.
Would you tell the judge your full first and last name, please?
Tamara Marie Grady.
Ms. Grady, back on the evening of May 31st of 2016, were you at a house on Manistique Street in the city of Detroit?
Yes.
At some point, did you see a person that you know by the name of Gregory Walker?
Yes.
When did you first see Mr. Walker?
When I sent him when he went to go get
I'm
the...
sorry, ma'am, I'm not able to hear you, so can you speak directly into that microphone for me?
Yes.
Okay.
Where was Mr. Walker when you first saw him?
He was at the house and we came out the house and he got the boy and tied him up with a rope.
Okay. Was he with anybody else when he tied the boy up with the rope?
Yes.
Who else was with Mr. Walker?
Lillian.
And who else?
And then, I don't know the other person's name.
Do you know who the other person was in relation to Lillian?
I guess the uncle or the brother, I don't know.
Okay. Do you see that person here in the courtroom today?
Yes.
Could you tell us where that person's sitting, please, or what they're wearing?
Right there, the third person.
The third person away from you? What color clothes is he wearing?
What's that, yellow?
Your Honor, the witness is indicating the seating position and the clothing of defendant number 3, Ernest Coleman.
Okay, you may continue.
So you didn't know that person's name at the time?
No, I didn't.
Where was that? What was that person doing?
He was a driver.
I interrupted you. I'm sorry. What was he doing?
He was a driver that's driving.
What was defendant 3 doing while Greg was tying the boy up?
They weren't doing nothing.
Where was defendant 3 while Greg was tying the boy up?
Lillian was in the back and the driver was driving.
And the driver was who again?
He was driving.
That's defendant 3, Mr. Coleman over there?
Yes.
Was the car moving while Greg was tying the boy up?
No.
Where was the car parked at that time?
Right behind skate land.
Behind skate what?
Behind skate land.
Skate land, right? And the street that runs behind skate land, is that Manistique Street?
Yes.
And is that where your house is?
No, that's not my house.
Does someone that you know live there?
Yes.
Who lived in that house on Manistique?
Gregory and Lillian.
All right. I want to clear up the timeline. While you were you ever inside of that house on Manistique Street?
I was at first.
And what were you doing while you were inside the house at first?
I would listen to the radio until I came outside and didn't know the boy was in the car.
So you were listening to the radio.
In the house.
You came outside.
Yes. Yes.
And then I couldn't hear exactly what you said. Did you say you did know the boy was in the car or didn't know?
I didn't know.
You did not know the boy was in the car?
No.
Who was in, at that point, who was in the car that you could see?
Just Gregory Walker, Lillian, and the driver and the little boy.
But you didn't know that the little boy was in the car?
No.
Are you certain it was the other 3 people that were in the car?
Yep.
What color was the car?
It was black.
And where was
A
it?
photo, black.
A black four-door. Where was the black four-door when you first laid eyes on it that night, when you first saw it?
It was sitting right in front of the house.
You've told us you didn't know the little boy was in the car.
No,
Could you see any 4th person? Did you
No, it wasn't no other 4th person.
So you could just see those 3.
With the little
Gregory,
boy.
Lillian, and the 3rd person that you've identified here today?
Yes.
Did you ever get into the car?
Yes, I did.
Once you got into the car, could you now see everybody that was inside of it?
Yes.
Who was inside of it? Once you're in it, you can look around and see the people. Tell us who was
It was Gregory Walker and Lillian and the nephew. And me, and that's it, and the little boy.
Okay, when you say the nephew, who are you talking about?
I don't know if that's the nephew or not, so I know that when I see him.
But the person you're
And
pointing
that's
at.
him. Yes.
And again, Your Honor, she's pointing towards defendant 3. She's describing him as the nephew. We're
Okay,
talking
you may
about Mr.
continue.
When you got into the car, did the car drive anywhere, or did you drive anywhere along with these other people?
Yes, I did drive with them, but they drove a whole lot of places, but I don't remember.
I should clarify my words that I'm using. Were you the driver or a passenger in the car?
I wasn't the driver at all.
Who was driving it when it first started to pull away from the house on Manistique?
The third guy.
Again, pointing towards defendant
Yes, the third guy.
3, Your Honor. Where did the car drive to?
I don't know. He drove a whole lot of places. I don't know.
While defendant number 3 over there was driving the car, what was happening inside of the car?
Gregory Walker was hitting the boy, and the boy was blocking his face.
What part of the boy's body was Gregory Walker hitting?
Like on the side right here.
Was he using an open hand like this, or was he like a slap, or was he using a punch like a fist like this?
Like a fist.
How many times do you think you saw Gregory strike that boy with his fist?
About 3 times.
And while he was doing that, you're telling us defendant 3 was driving the car was moving?
Yes.
All right. Did you ever see anyone tie the boy up?
Yes.
Tell us when that happened. First, let me ask, was the car moving when that happened, or was it stopped somewhere?
It was stopped.
Where was it stopped?
In front of Manistique.
Manistique house?
Yes.
Who tied the boy up?
Gregory Walker.
Did you ever see Greg get out of the car in order to tie the boy up?
Yes.
Tell us about that.
He got out the car, went over there to the house, and got a white rope, and came back with some gloves in his hand, and tied the boy's hands up first, and then he did the legs.
While Gregory left the car to go get the rope and the gloves, who stayed in the car?
The driver, and me, and Lillian.
The driver again being defendant number 3?
Yes.
What part of the boy's body did Gregory use to tie up with that rope?
He started off with his hands, and then after his hands, he did his feet. And then I had told him to unloose his hands and his feet, and he did. And that's when he pulled the boy out the car and started choking the boy up, and then the boy started doing like that, and then he let him go. And then he put him back in the car.
When Gregory was choking the boy, was he using his hands around the boy's neck, or was he using his arm around the boy's neck?
His arm.
How long would you say that went on for, that he was using his arm to choke the boy?
Not even, 5 or 10 minutes, not that long.
Was that going on inside of the car or outside of it?
Outside the car.
Do you see Lillian in the courtroom here today?
Yes, I do.
Tell the judge where she's sitting and what she's wearing, please.
She's sitting in the second seat with the green on.
Describing defendant number 2, Lillian Roberts, Your Honor. What was Miss Roberts doing while Gregory was choking the boy as you've described?
She really basically wasn't doing nothing at all.
Where was she?
She was in the back seat. She wasn't doing nothing at all.
And where was defendant number 3, Mr. Coleman, over there? What was he doing, or where was he while Greg was choking the boy?
In a car.
At some point, did Greg stop choking the boy?
Yes.
And the boy made that sound as you described for us?
Yes, I did, yes.
After the boy made that sound and Greg stopped choking him, did Greg ever put the boy back into the car?
Yes.
And what happened at that point?
Then after that, we just rolled around, and then after that, I told them to drop me off, and then they dropped me off, and I don't know where it was. It was like a dark street.
Okay, let me ask a couple questions about this. When you say we rolled around, who drove the car away from the house on Manistique after the choking?
The third boy.
Again, pointing towards and describing Ernest Coleman, Your Honor. So you asked to be dropped off?
Yes.
Did they ever take you somewhere to drop you off?
No, but they just dropped me off right there on Warren.
On Warren?
Yes.
Was that near the home that you were trying to get to?
Yeah, but it was a little farther down. Now I had to walk.
Did you ever see a gun in the car?
Yes.
Who was holding the gun when you first saw it?
Gregory Walker.
Did he ever give it to you or to anybody else?
No.
Did you ever touch that gun?
Yes.
Tell us about the circumstances. At the very moment that you touched the gun, what happened?
I had passed it to Lillian.
Okay.
I'm sorry, I didn't understand what you said. What did you say? Repeat what you said.
I said I had passed it to Lillian.
You passed it to Lydia?
Yes.
Okay, thank you.
Do you remember ever writing out a statement to the police about that gun?
Yes, I did.
Okay. And in fact, you and I talked about it this morning, right? I showed you the statement and we read through it together?
Yes.
Now, you recall that in that statement, it's written down that you passed the gun to Ernest. Do you agree that that's written in the statement?
Yes.
Did you ever tell the police that you had passed the gun to Ernest?
Yes,
I'm using the name Ernest. What the statement actually says is Lillian's son. Do you agree that the statement says you passed the gun to Lillian's son?
Yes.
Did you ever tell the police that it was actually Lillian's son who you passed the gun to?
Yes, but I ain't say the name, but I ain't know the person's name, so yes.
Okay. Thinking back on it, did you in fact, when you passed the gun, did you give it to Lillian or did you give it to Lillian's son?
Lillian's son.
At the investigative subpoena, when you came to this building and met with a prosecutor on June 4th, do you remember being asked that same question?
Yes.
And the prosecutor at that time said to you, or asked you, did you see Greg with a gun? This is on page 11, line 7. Is that, and then on page 11, did you see Greg with a gun? You said, yes, I did. Is that true? And your answer was yes. You were asked on line 11, what type of gun? The handle was brown, it was black. He passed it to me and I gave it to Lillian's son. Is that the truth? And your answer was yes. But I wasn't the only one who put my hands on it. So would you agree that at the investigative subpoena you also said it was Lillian's son whom you passed the gun to?
Yes.
Tell us about that. Why were you taking the gun from? Why was Greg handing you the gun and then you giving it to Lillian's son? What was the purpose of that?
I don't know.
What did Greg do immediately after handing you the gun?
That's when I had passed it to the third guy.
Well, what did
The
Greg
driver.
do? Who was driving at that time?
The third driver. The driver. Just sitting there, I'm putting it.
Okay. So he was driving the car and you handed the gun to him?
Yes.
What did Greg do after?
Okay, I'm sorry, Mr. Sturman. Is something going on in that back row? Help whoever is, somebody keeps moving their feet. I can't function that way. So, not the young lady on the end, but the young lady with the white sweater on. She's moved over once, moved over again. She needs to find a seat and stay there. That's making me uncomfortable. When I'm uncomfortable, everybody's going to be uncomfortable. Pardon my interruption, Mr. Sturman. You may continue.
You're still saying that Mr. Coleman, defendant 3, was the one driving the car, right?
Yes.
And did you hand the gun to him?
Yes.
After you handed the gun to him, where was defendant 1, Mr. Walker?
He was sitting in the car.
What was he doing after you handed the gun to defendant 3?
He was still, he got out the car. They went to the gas station. They got out the car, went to the gas station. That's when Greg got in the car and passed the gun to me, and I passed it to Lillian's son.
Okay, so the gun passing incident happened at a gas station?
Yes.
And on that occasion, Greg also got out of the car for some period of time?
Yes.
How long was Greg out of the car at the gas station?
Not even, 2 or 3 minutes, he got into his driver's side.
2 or 3 minutes he was out of the car?
Yes.
Okay. Did you see where he went during that 2 to 3 minutes?
No, he went around the car and got into the driver's side until the third person went into the gas station and came back out.
So then at that point, when you leave the gas station, is Greg Walker driving the car down?
No.
All right, I see. He got into the driver's side. When you said driver's side, do you mean the front driver's seat or the rear driver's side passenger seat?
The driver's side.
So
I'm sorry, what was the answer?
I'm mucking things up, I think, Your Honor. I'm sorry. You said that Greg got into the driver's.
You didn't say monkey.
He did, Judge.
Yeah.
Okay, I'm sorry.
Goodness gracious. So you
Mr.
can't. I'll let you tell it. When you leave the gas station, what seat of the car did Greg Walker get into?
The driver's side.
Okay.
Then after the driver's side, that's when the
Let me
third...
interrupt. I'm going to interrupt here for a moment because you said driver's side, right? But the car, it was a 4-door car, right?
Yes, it was.
Was he getting into the front driver's side or the rear driver's side?
The other side, like the driver's side.
The car has a steering wheel, right?
Yes.
Was Greg Walker sitting behind where the steering wheel was?
Yes.
So now is Greg Walker driving the car at this time?
He wasn't driving it, but the third person that got back in the car, the one that went inside the gas station and came back out. And Greg got out and sat behind the boy.
Okay. So when you leave the gas station, Greg is again sitting behind the boy.
Yes.
And defendant 3, who you call Lillian's son or nephew, was driving the car.
Yes.
All right. Thanks for clearing that up for us. So.
No problem.
The person that was doing the choking, do you see that person here in the courtroom?
Yes, I do.
Okay. Could you tell the judge where he's sitting and what he's wearing, please?
He's sitting right there in the first seat, right there,
With that description,
with the yellow on.
the witness is describing the position and the clothing of Gregory Walker. Judge, I don't have any other questions for Ms. Grady that's submitted for cross-examination.
Okay. Mr. Campbell?
Thank you. All right, Ms. Grady, good afternoon.
Good afternoon.
All right, Ms. Grady, I'm going to ask you some questions, okay? And if at any time I don't make my question clear or you don't understand what I'm asking, just let me know and I'll re-ask it. I'll do a better job, okay?
Okay.
All right, thank you. All right, Ms. Grady, so you were picked up in this vehicle, and that was at the house on Manistique, is that correct?
Yes.
And that is not your house, correct?
No.
All right, do you know whose house that is?
Lillian.
And had you been there, you said you would listen to the radio and you were sort of hanging out prior, is that correct?
Yes. Yes.
How long had you been in that house approximately before you were picked up?
Maybe probably because I've been over there, not all day, but I've been over like an hour and a half. And I ain't know what was going on. After that, I ain't know what was going on.
There were some people over earlier in the day having sort of a barbecue or something, is that right?
I think so, because I wasn't there at the barbecue.
Okay, and I don't want you to guess, so you're not sure.
I'm not sure, yes.
But you had been at the house, you said about an hour to an hour and a half before you got picked up in the car, correct?
Yes.
And when you first get in the vehicle, you said it's the three defendants, and I represent Mr. Walker. My client is sitting in the back seat, correct?
Yes.
Right. And at that point, the young man in the front seat is not restrained in any way, correct?
Yes.
And you then said that the car drove to a whole bunch of different places, is that right?
Yes.
All right. And were there some instances in which the car would pull up somewhere and the car would stop, and then Mr. Walker would get out of the car?
Yes.
How many times approximately, if you remember, did the car stop and Mr. Walker get out of the car and walk around?
Yes.
No, how many times?
About 2 times.
2 times. Okay.
Yes.
In fact, there was one time where Mr. Walker went to the front door of a house and started knocking on the door. Do you remember that?
Yes, I do.
All right. And were there any other instances in which Mr. Walker got out of the car and went to a house to go investigate?
No, yes, I was, yes.
Yes, there were other times.
Yes.
Okay. So, at least 2 times where Mr. Walker gets out of the vehicle to go investigate a home, and there was one instance where you said that everyone went to a gas station, correct?
Yes.
All right. And on that instance, Mr. Walker got out of the vehicle, is that correct?
Yes.
Now, Ms. Grady, you, as Mr. Surma asked you, you remember giving a statement to the police that was put into writing, correct?
Yes.
All right. And you also testified, you gave a statement when prosecutors were asking you questions, correct?
Yes.
All right. And on both those occasions, you indicated that you were giving truthful statements, correct?
Yes.
All right. And then, do you remember being asked how many times Mr. Walker got out of the vehicle, and do you remember answering only once?
I think so, not for sure.
Okay, and I'll get specific. And specifically, do you remember being asked, and I'm at page 14, let's start at line 9, being asked these questions and giving these answers. Question, we went to his mama house first. When we left the boy's mama house, they kept riding around with him. And I was there with him. I just told them to drop me off somewhere on Warren, and I walk all the way home. Question, so the car only stopped 1 time, and Lillian and Gregory got out only 1 time? Answer, yeah, only got out 1 time, and that's it. Other than that, they ain't got out nowhere, else I told them to drop me off. I don't know where they went after that. Ms. Grady, do you remember being asked those questions and giving those answers?
Yes.
Okay. So on that day under oath, you said the only time that they stopped and got out of the vehicle was to investigate this home that was believed to be this young man's mother's home, correct?
Yes.
And that's certainly different than the testimony you've given today. Is that right?
Correct.
Thank you. In fact, in your statement to the police, you didn't give any reference of going to a gas station or anything like that, did you?
No.
Okay. And you didn't mention anything about going to Lillian's house either, did you?
No.
Thank you. You said that today, at any rate, you said you testified and you stopped back at Lillian's house on Manistique. Is that correct?
Yes, but it wasn't by myself.
Oh, no. And let me ask a better question. So you're picked up from the house on Manistique and you drive to a number of locations. And when I say you drive, you're in a car that travels to a number of locations, correct?
Correct.
All right. And at some point you end up back at the house on Manistique. Is that correct?
Yes.
All right. And that's the time where Mr. Walker, you said he gets out and he has some string. Is that right?
Yes.
All right. And you said today, do you know where he got the string from?
From on the Saturday house.
From where, I'm sorry?
On the Saturday house.
On the side of the house. Okay. And again, Ms. Grady, I'm going to refer you back to when you were questioned by the prosecutor at that investigative subpoena, page 15. We'll start with line 8. Question, where did the string come from? Question, where did the string come from? Answer, the white string. Question, the string to tie the boy, where did it come from? You know what? I apologize. Wrong page. Sorry. Page 17, line 16. Question, so did Gregory leave the car and go into the house to get the plastic bag? Answer, he must have went in the house because I ain't seen him when he went in the house. The only thing I seen him leaving to go get those gloves, I guess he already had the rubber gloves and the string outside, I guess. I don't know where he picked up the string or the bag at. So you don't really know where the string came from, is that correct?
No, I did not know.
And finally, earlier you testified that when you talked to the police, you didn't give anybody any names, correct?
Correct.
All right. You didn't say, Anthony Young, for example. Did that name ever come out of your mouth?
No.
All right. And so the statement you give to the police, this is not in, you remember, this statement that you gave the police with your signature on it. Your Honor, can I approach very briefly?
Yes, you may, and you've already shown the prosecutor what you're approaching.
Absolutely.
Okay, thank you.
Ms. Grady, these 3 pages I'm handing you, is that your signature at the bottom?
Yes, it is.
All right, and is this the question and answer statement that you gave to the police?
Yes.
All right, but the questions and answers, those are not in your handwriting, is that correct?
Yes.
Okay. And so if any names are mentioned in here, you said you didn't mention anyone's name, correct?
Yes.
All right. So if there are any names mentioned in here, that's something the officer wrote down, but you did not say. Is that correct?
Yes.
So if there are names in this statement, it's because the officer put those names in there. You didn't say them, correct?
Correct.
I have nothing else, Your Honor. Thank you.
Good afternoon, young lady.
Good afternoon.
My name is Lillian Diallo. I represent Lillian Roberts. I'm going to ask you a series of questions. If you do not understand it, let me know and I'll do my best to clear it up, okay?
Okay.
So that we're clear, the only person you saw hitting the boy was Mr. Walker, correct?
Yes.
You did not see Lillian Roberts ever put her hands on that boy, correct?
No.
Okay. As a matter of fact, did it appear to you as if the person in control was your uncle, Gregory Walker?
Yes.
And he's your uncle and you love him, correct?
No, I don't love him.
Oh, but that's your uncle though, right?
Yes.
Okay. And it hurts you to have to be here to tell the truth about what you saw, correct?
Correct.
Okay. And you have a cousin named Anthony Young, correct?
Yes.
They call him Pooh Man or Boo Bear or something, right? What do they call him?
Call him Pooh Man.
Pooh Man. And Pooh Man was in the car at some point in time when you were in the car, correct?
He wasn't in the car with me at the time when the little boy was in the car. He wasn't in the car at the time.
Okay. When the little boy and the young person was in the car, when he first pulled up, you said my client was in the car, correct?
Yes.
There were no bruises on this child whatsoever, correct?
No.
Nobody was in distress at that time, correct?
Correct.
Okay. And then, at some point in time, the night progresses, and you hear your uncle questioning the little boy, correct?
Yes.
Miss Roberts didn't question him, did she?
No.
Okay. And you saw a person strike the little boy after you got in the car, correct?
Yes.
And that person was?
Gregory Walker.
Okay. And you never called 911, correct?
No.
Do you know if your cousin Pooh Man or Anthony Young called 911?
No.
Did you ever see your cousin strike the little boy?
No.
Did you ever strike the little boy?
No.
You are testifying here today under a grant of immunity, correct?
Yes.
Okay, so that you could not be prosecuted for anything that you might have done, correct?
Well, no,
Yes.
that's a mischaracterization of the grant of immunity. It's an
It's
important
you.
distinction.
Oh, it's you?
Right.
Oh, I'm sorry. It's not full immunity. Did you know that?
No.
Oh. Okay. Maybe the lawyer should be here.
Did the lawyer leave?
I think the lawyer left, Judge.
Ms. Slomsky characterized it as use of immunity on the record when she was describing to the court. I would rely on Ms. Slomsky to have thoroughly gone over that with her client, and I know I've talked about it with...
And she can't tell me what her attorney,
Right.
she can't tell us what her attorney talked about anyway, so continue with your cross.
I'll do my very level best, Judge, not to do anything. Well, I'm representing Ms. Roberts. But in any event, you never saw Ms. Roberts with a gun in her hand, correct?
No.
And we're clear about that, correct?
Correct.
Okay. And what, you were never in the car with Anthony Young?
No.
So this was just a different part in...
Yes, it's a different part.
Okay.
Yes.
But hold on. It's fair to say that you guys have talked about this situation, correct?
You talking about Anthony Young?
Oh, yes, Anthony, you and Anthony.
No, me and me never talked about this. Nothing. I don't even know his number to try and talk to him.
Okay. I don't have any other questions for you.
Okay, Mr. Daly?
Thank you. Can you tell us your date of birth first,
10/25/83.
which makes you 32 right now?
Yes.
What was the date of the incident that you just described? The date?
I don't know exactly what day. I don't know.
You don't know the date. Do you know the day?
No, I don't.
Before you got into the car, the black car, had you been drinking any alcohol?
Yes, I have. I have been drinking, but I wasn't drinking a lot.
Did you say you were drinking a lot?
I said I wasn't drinking a lot.
What were you drinking?
I was drinking on a little beer and a cooler, and that's it.
A little beer. How many?
Just one beer and one cooler.
And one cooler.
Yes.
What about drugs?
No.
No marijuana?
No.
When you went out to the car, did somebody ask you to come out to the car?
No.
You went on your own?
Yes, I went on my own.
And where were you going?
Well, I was going out to the car trying to see if I can get a ride home, but I ain't know that the little boy was in the car.
So you just wanted a ride home, nothing more, right?
Nothing more than that.
And how far away did you live from the Manistique address?
Right there on Happy Hill.
How
and
far
Warren.
away?
I don't know.
Block? 2 blocks?
Maybe so, yes.
Okay, 1 or 2 blocks you needed a ride. Right?
Yes.
Did you know that the car was out there before you went out there?
No.
Where was the car when you went out of the house?
It was parked right behind Skateland in front of the house.
Okay, parked in front of the house on Manistique, correct?
Yes.
And who did you talk to first?
I ain't talked to no one.
You just got into the car?
Yes.
And where's Mr. Walker, your uncle?
Sitting right there in the first seat,
Front or back?
the back seat.
And is the little boy back there too?
No, the little boy was in the front seat.
Right. And then Lillian is in the back seat, correct?
Yes.
And you said the man who's sitting here, who's been identified as defendant 3, was behind the driver's wheel, correct?
Yes.
Now, you referred to him as Lillian's uncle, Lillian's brother, Lillian's nephew, right? All of those.
Yes. But I just didn't know which one it is to her.
Do you remember in your statement that you indicated that the person that we're speaking about, the driver, was Lillian's son, right?
Yes.
But you didn't know that at the time, did you?
No, I didn't.
Who told you that the man over here was Lillian's son? Who told you that?
Nobody didn't tell me. I just figured that he probably would have been her son.
You just guessed?
Yes.
Because you didn't know his name,
No, I didn't.
didn't know his nickname,
No, I didn't.
wasn't a friend of yours,
No, I didn't. Nope.
and you'd only seen him what, once, twice
Yeah,
before?
maybe once or twice, yeah.
Never talked to him,
Never talked to him.
didn't know nothing about him.
No.
So even now today, you're just assuming that he is Lillian's uncle, brother, nephew, or son. One of those, right?
Right.
Did you ever say anything to the driver that night?
No, I didn't.
Did he ever say anything to you?
No.
Did you ever hear the driver say anything to the boy?
No.
Did you hear the boy say anything to the driver?
No.
In fact, during the entire incident, the only thing that the driver did was to drive the vehicle, right?
Correct.
In fact, earlier you said the driver did nothing. You remember saying that just a few minutes ago?
Yes.
So at no time did the driver of the vehicle, who's been identified as defendant 3, he never had any rope, did he?
No.
Never had any gloves?
No.
Never touched the boy in any way, did he?
No.
You're agreeing with me, right?
Yes.
Now, when you got into the vehicle for a ride home, they drove to a number of different locations, right?
Correct.
And they were looking for the boy's home. That was your understanding, correct?
Yes.
That's what Mr. Walker had said, correct?
Yes.
And was it your understanding that they were going to take the boy to his house and drop him off?
Maybe, yeah.
Okay. But there were some problems about trying to locate where he lived, right?
Yes.
And did it appear to you that the boy wasn't giving accurate information about where he lived?
No.
That wasn't your impression?
No.
And where are you sitting in the vehicle?
Behind the driver.
So it's you behind the driver, then where's Mr. Walker?
Behind the little boy.
And Lillian's in between Mr. Walker and you in the back seat?
Yes.
At some point, the car stops and Mr. Walker gets out, right?
Correct.
And when Mr. Walker got out, did the driver stay in the car?
Yes, he did.
And Mr. Walker, is that when Mr. Walker went and got the string, the white string?
Yes.
And then he came back and he took the boy out of the car, correct?
Yes.
And did he take the boy out of the car to the back of the car?
No.
To the side of the car?
To the front of the car.
And That's where he tied him up.
Yes.
And did he also untie him outside the car?
Yes.
And is that where he hit the boy, outside of the car?
Yes.
And that was the only place that he hit the boy, outside of the car?
Yes.
So he ties the boy up outside the car, unties him, and also hits him outside the car, correct?
Yes.
And is that also when he choked the boy outside of the car?
Yes.
And it was only Mr. Walker who choked the boy
Yes.
using his arm?
Yes.
And everybody else stayed back in the car when that happened, right?
Yeah.
Now, when he brings the boy back into the car, the boy is still alive. He's not dead, right?
Yes, he was still alive after they dropped me off.
Right. We'll get to that in a minute. But when Mr. Walker brought the boy back into the car, where did Mr. Walker put the boy?
In the front of the car.
You mean in the front seat?
Front seat, yes.
Okay. The boy's still alive, correct?
Correct.
You could tell that, right?
Yes.
And was Mr. Walker still talking to the boy after he choked him and put him back in the car?
Yes.
Okay. And was the boy talking back to him?
Yeah, the boy was talking back.
Okay. So now they're both talking, and everybody's back in the car. And where does the car go from there?
I don't know. It was just so dark. I don't know where everybody. I don't know.
Okay, but eventually it gets back to the Manistique house, correct?
Yes.
Do you know how much time passed from the point where Mr. Walker put the boy back into the car to the point where you get to Manistique? How much time passed?
I don't know.
If I told you, say, an hour, is that about right or too long?
Maybe too long.
Half hour?
Maybe, yeah.
Okay, around a half hour they drive around. The boy's still alive, right?
Yes.
And during that time, Mr. Walker doesn't strike the boy anymore, right?
Right.
Doesn't choke the boy in the car, right?
Right.
And then they drop you off at Manistique, right?
They ain't dropped me off back there. They took me on Warren and I walked the rest home.
Okay, so they drop you off at Warren, not Manistique.
No.
Warren, correct?
Yes.
Boy's still alive.
Yes.
You talked about being at a gas station at one point, correct?
Yes.
And Mr. Walker got out?
Yes.
And the driver got out?
Yes.
And was that the first time you saw the gun?
Yes.
Mr. Walker had it.
Yes.
Did you stay in the car?
Yes, I did.
And when you stayed in the car, where were you sitting at that time?
Behind the driver's seat.
Okay, in the
In the
back
back seat.
And did Mr. Walker get into the car
Yes.
with the gun
Yes.
and gave it to you
Yes.
in the back seat?
Yes.
And Lillian was sitting next to you.
Correct.
The driver, meaning the third person, he's still in the driver's seat, correct?
Yes.
Did Mr. Walker tell you what to do with the gun?
No.
Did he tell you why he was giving you the gun?
No.
Did you want to have the gun in your hand?
No.
So you wanted to get rid of it?
Short of, yeah.
And you gave it to somebody else?
Yes, I did.
And what you said initially is, you said just a minute ago, under oath here, that you passed it to Lillian, who would have been the person sitting next to you, right?
Yes.
You were sitting behind the boy on the passenger side?
What, the little boy that was in the front?
Yes.
No, I wasn't sitting behind him. Gregory Walker was sitting behind him.
Okay. And when you gave the gun to somebody else, did you say anything?
No, I didn't.
And do you know what happened to the gun after you gave it to somebody else?
No, I didn't.
You don't know if they kept the gun or gave it to somebody else?
I don't know.
You never saw it again?
No, I never saw it no more after that.
Do you remember how you had the gun when you gave it to somebody else? Where'd you have in your hand?
I had it upside down and gave it to one of them. I don't know who I gave it to, but I gave it to somebody because I didn't want to have it in my hand.
Okay, so the idea was that you would get rid of it as soon as you could, right?
Correct.
And you wanted to give it to somebody else, most likely the person closest to you, right?
Yes.
And that would have been Lillian, right?
Correct.
And you just told us now that you're not certain who you gave the gun to. You just got rid of it, right?
Right.
So you gave it to somebody else, right?
Yes.
Most likely Lillian, right?
Yes.
So, what did you do wrong that night?
I ain't do nothing wrong.
Do you know why the prosecutor gave you immunity if you didn't do anything wrong?
No, I didn't.
What's your understanding of the immunity that you were given?
I don't know, sir.
When did you first talk to the police?
After I went to the house on Haverhill and Warren,
Did they come to you or did you go to them?
they was already there at the house when I got there.
And did you make a statement there, meaning at the house?
Yes, I did.
Was that just a verbal statement or was it a written statement?
There was a written statement.
And did you give more than one written statement?
No.
And after you gave the witness statement, then you were asked to come down and give a sworn statement at the prosecutor's office?
Yes.
And did you do that?
I don't remember.
All right. Did there come a time when you found out that the police were looking for you after you came down to the prosecutor's office?
No.
You never heard that they were looking for you?
No.
Nobody came to your house? Never, not the police, never came looking for you?
No.
Did you hear through relatives or friends that the police were looking for you?
Yes.
And did you call the police up and tell them where you were at? Or were you hiding?
No, I wasn't hiding. My auntie had told me that somebody had called her phone for me.
And? What did you do about that?
After that, don't know.
What do you mean you don't know?
I don't know what happened after that. I don't know.
Did you ever call the police or did they come get you?
They came and got me.
Were you arrested?
No, I wasn't arrested.
Were you ever put in custody?
No.
When did they pick you up?
I really don't know on that one, sir.
Was it today or a date some other time?
Some other time.
How did you get to court today?
One of the detectives.
Have you been convicted of a crime involving theft or dishonesty in the last 10 years?
No.
Do you go by any other name than the name that you've given us here?
No.
Did Mr. Walker ever point the gun at the boy?
No.
Did he ever threaten the boy with the gun?
No, not that I know of.
That's what I'm asking. What you saw or what you heard, you never saw Mr. Walker say anything threatening to the boy with a gun, right?
Correct.
And no one else did either, right?
No.
Nothing further, thank you.
I want to clarify something that Mr. Daly asked you about. When you came to this courthouse today, who drove you here?
One of the lady detective.
Was she wearing a police uniform or was she wearing a suit? Police clothes?
She was like wearing like a regular suit.
And you knew she was a police officer, right?
Yes.
So when he asked you, when did you get picked up, I think your answer was some other day. What I want to know is, when did you get picked up today? What time did they come to your home to take
They
you?
They came around by what, after 8:30?
8:30 this morning?
Yes.
And when you talked to the detectives, when they came, did they explain to you that you had to be in court, you had to come with them?
Yes.
Did they tell you that they could arrest you if
I'm
you
objecting
refused?
to the leading nature of the question, Judge. Hold on. I'm in the bathing chair, Judge, so I don't
Okay.
take a while.
Okay, this day, it's
Thank you.
your question.
What did the police say to you exactly about coming to court?
They really didn't tell me nothing. They just, we just drove all the way straight here. Nobody want to talk to me or nothing. She want to talk, saying nothing to me.
Did you know prior to this morning that police were looking for you and wanted you to come to court to testify?
Yes.
Now, this issue of the gun and who you passed it to. When I was asking you questions earlier, you remember agreeing with me that you had said in the past that you handed the gun to Lillian's son.
Yes.
And then when Mr. Daly just asked you that, he was using the words handing it to some other person, and you agreed with him. Do you remember doing that?
Yes.
And he said, did you hand the gun to Lillian, and you agreed with him on that? Well, those
record should indicate she's not.
Yes.
Okay. You see how those are two very different things. Either you handed you handed it to Lillian, or you handed it to Lillian's son.
To Lillian's son.
Is that what you did? Who did you hand the gun to?
To Lillian's son.
And once Gregory got out of the car to go, well, at the gas station, once Gregory got out of the car, who was then holding the gun?
Lillian's son.
I have no other questions, Ron.
Okay, thank you, ma'am. You are excused. The deputies will tell you how to leave the courtroom.
Judge, people have no other witnesses to present.
Thank you. Will any of the defense counsel?
Could I deal with one other issue with regards to this witness?
Yes.
Detective Hauser tells me, and I think he would let the court know this as well, he did not actually place the witness under arrest. He did not enforce the witness detainer that this court had ordered because she agreed to come with him. So technically she was never placed under arrest, but I'd still like the court to sign the order of detachment, I think it's called, that releases the witness from that obligation.
And the court will definitely do so. Thank you. Will either of the defense attorneys be calling any witnesses on behalf of their client?
Not for Mr. Walker, Judge, thank you.
No, Judge, I guess we didn't get an opportunity to brief Fox. I just wanted to ask specifically about the weapon, but I guess Your Honor has. Is she clear?
I'm very clear.
I'm very clear too.
Okay, thank you, Mr. Daly. Okay, thank you. At this time, the people may proceed with their motion.
So Judge, I'll begin with count one, which applies only to Mr. Walker.
Hold on 1 second, let me just get the complaint. Officer in charge, there were some other individuals who left the courtroom after that witness left. Are they?
They roll together.
Oh, okay. Just making sure everybody safe and sound. Thank you. Okay.
Thank you.
Mr. Thurman, you may proceed.
Just to count one in regards to, well, first I want to move to amend, move to consolidate the two complaints so that they'll be together on one information and ask, when I'm asking you to find this over to the circuit court. So beginning with count one as it applies to Mr. Walker, first degree premeditated murder, the court heard the testimony of probation agent Jacqueline Draheim, where the defendant admitted to her the circumstances of how Deontae died. She even demonstrated the chokehold that he described for her. He, in his interview with her, he indicated that it was an accident, but I think the court can look past that and consider the other evidence, the other facts and circumstances of this case. And I think it's probable to come to the conclusion that he was angry, that he had a motive to kill, and that it was something that was thought out during the course of the 5+ hours of Deontae's captivity. But we certainly heard testimony that he caused the death. It was premeditated and deliberated. As to count two for felony murder, all three defendants are charged with that. counts defendants 2 and 3 under an aiding and abetting theory, and the aiding and abetting theory applies really to counts 3, kidnapping, 4, torture, and 5, unlawful imprisonment as well. But it's clear from the testimony, but more specifically from the admissions that Mr. Roberts and Mr. Coleman make, that Mr. Walker couldn't have done this alone. They both played integral roles in keeping Deontae captive, again, for that 5+ hours that he was in their car. They're the driver. At times, Mr. Coleman's holding the gun, but most of the time, Mr. Walker has the gun. Mr. Walker's doing the assault of the child. He's tying the child up, but he can't do that unless the car's moving. And as I think Ms. Roberts even discussed in her statement to the police, which was received as evidence by this court, that she was driving and she was in the car in case the little boy decided to run. They could prevent that from happening. So you see clearly, in terms of felony murder, there are aiders and abettors.
Now, counsel, I didn't see that in Ms. Roberts' statement.
I believe Ms. Roberts...
There was some testimony in one of the statements where it was believed that, it wasn't Ms. Roberts who said it, someone else said that Ms. Roberts was there so that they guessed, so that Mr. Walker could jump out and grab the one boy. So, just in case they saw the other child. That was the testimony. But you may continue.
No, I'll rely. I'm sure the court's memory and notes are thorough, so I'll rely on...
I'm sure too.
Yeah.
Thank you.
The other aspect of felony murder is that there has to be some intent. Either intent or knowing that you're creating a very high risk of death or great bodily harm with the knowledge that death or great bodily harm was the probable result. And there's one case I wanted to cite for the court, People v. Wilson. It's an unpublished Court of Appeals case, 2013 Westlaw 276029. 276029.
Do you have a copy of that?
I do. It describes a situation where the defendant was participating in an armed robbery, knew that an armed robbery was going to be occurring, drove a short distance so that the person could perpetrate that armed robbery, and then came back after and picked the person up, but was not present at the time that the victim was killed. And I think that that's an important parallel to this case, where Ms. Roberts tells us in her admission that she was present. She was driving the car at the time that Mr. Walker choked Deontae to death. However, Mr. Coleman, we don't have any evidence that he was in the car or present when the child was actually killed. What we do have is that he's at times driving a car. He's participating in the captivity for, again, more than 5 hours. He knows that one of the defendants is armed with a gun, and he himself is actually holding that gun at one point. He knows that he's driving a vehicle while defendant number one is slapping, punching the child. The child is tied up at one point. And the child is choked at one point while Mr. Walker's wearing gloves. Choked to the point of gasping or choking, as Ms. Grady demonstrated for you today. So we would argue that there's probable cause to show that all three defendants should have known or were wanton and reckless, and that there was a likelihood that the natural tendency of the behavior was to cause death or great bodily harm, and to satisfy that second prong of felony murder. As to kidnapping, we're relying on...
You've only charged Walker and Roberts with kidnapping. You may proceed.
We've charged Mr. Coleman with kidnapping on that separate complaint. That was the first charge that was issued in this case.
We're going to consolidate.
Yes.
Is that correct? Okay, thank you, counsel.
Great. So kidnapping goes to all three defendants, and again, kidnapping requires more than just captivity. It requires some of those specific things that are laid out in the statute. Here we're arguing that Deontae was held for ransom. It's clear that throughout the testimony, the point of taking the child was for Mr. Walker to get his money back. You heard from the one witness, Mr. Young, who actually tried to convince him, hey, I'll pay you for this. I'll pay you the $70 if you let the kid go. He clearly wants his money back, but the testimony that goes directly to ransom was that of Cedric Bell, who said the car pulled up at his house. They asked for his stepson Javion by name. Ms. Roberts was out of the car at that point. and Mr. Walker was in the car, and I think the quote was, "I'd better get my money back or I'll put a bullet in him. I already have his friend." It's a direct request for, "I want my money or else this is going to happen. We're holding this child captive in exchange for money." And so on the kidnapping charges for all three defendants, we're asking the court to consider that, the demand for ransom to support the kidnapping charge. As to felony firearm, the case is well noted at People v. Moore at 470 Michigan 56, that to aid and abet felony firearm, it just requires that the person do something to help in possessing or carrying that firearm. And again, clearly, just the physical aspect of how they were performing this captivity. It's difficult to drive a car and to maintain control over a weapon at the same time and to look after your captive. And defendants 2 and 3 aided and abetted in that. At different times, they each admit to being the driver of the car, while defendant 3 is armed with that pistol, and they knew he was armed with that pistol. The pistol, again, was an integral part of keeping Deontae captive, one of the many reasons that he would not have tried to escape. For counts 7, 8, and 9, there's been stipulations as to the defendant's criminal histories that would prevent them from being in possession of a firearm, constructive possession or otherwise, as it applies to each defendant. And then finally, I'll go back to count 4, torture. Torture could be either extreme physical or mental pain and suffering. So from reviewing the medical examiner's report and from some of the testimony, I'd say there is some argument that this was extreme physical suffering, but our argument rests mostly on the mental aspect of it, extreme mental pain and suffering. And I asked the court not to apply it to the standard of an adult in the situation, but to a 13-year-old boy. We know from the timestamps on the videos that he was taken at gunpoint from that party store at 11:19 p.m. That was in Exhibit 8. We know that they were all together with the defendant, with Deontae, at the Creektown Casino. The timestamp on that video is 4:37. So we know that this 13-year-old boy was their captive for a minimum of 5 hours and 18 minutes. That he's present in the car with these 3 adults, and at times as many as 2 other adults. He's bound, hands and feet, not through the entire incident, but for some portion of it. He's constantly being slapped and hit, asked where he lives. He's not giving the answers they want. And at one point, he actually appeals to the maternal instinct of defendant 2 when he looks at her and he says, "You're not going to let him hurt me, are you?" And keeping all of this in the context of a 13-year-old boy, the medical examiner's report describes him as 5 feet 1 inches tall and 110 pounds. I think the court can consider all those things and find that there was extreme mental suffering intentionally inflicted by these 3 defendants, and that's why we're asking the court to bind over the torture charge as well.
Okay, thank you. I don't want to start with Mr. Walker. I'm going to start with Ms. Roberts.
Thank you. Judge, while this certainly is a troubling case,
It is.
it's certainly horrendous,
It is.
Judge, but in order to go forward, we have to legally look at each person and their role. And the testimony of every single witness, and I'm not trying to throw anybody's client under the bus, but that it was Mr. Walker who was in control. It was, and so we're clear, the time stamp that says 11:19, as the prosecutor, is being forthright, Mr. Walker was by himself at that store at the initiation of this whole situation. And I don't think he's trying to pretend that it was anything other than what it is. And
I agree with you at that point.
Okay.
That Mr. Walker was the one that took the little boy and put him in the car. Now,
okay,
I need you to talk about Ms. Roberts.
I am, Judge.
Once that child is in that car and brought to a house where she lives, and now she's in it.
Judge, yes, but in it as to what, though, Judge? And you know, if merely present is not a crime, you have to do something in furtherance of the enterprise, and it doesn't appear, nobody thought that this little boy was going to be killed. That was the testimony of each and every person.
Other than the little boy. There was testimony that your client gave in her interview that said The little boy asked me, "You're not going to let him hurt me,
Correct.
are you?" Yes. Somebody thought that
Judge.
that little boy was going to end up dead.
Not dead.
And it was the little boy who
Not-
thought something was going to happen to him. And he specifically asked your
Understand.
client,
Judge,
"You're not going to let him hurt me."
the maternal instinct is clear, Judge.
Whose maternal instinct?
Well, not hers, but
Oh,
I understand yours, Judge. And what you're saying, even if that is what he said, she has no duty, and it's as repugnant as it is. She can't stop him. Who can stop him? She never had a weapon. She never did anything to hurt the little boy. She never put her hands on him. He's tied up outside of that car. He's choked outside of that car. She's not out there when that happens. And yes, it is absolutely repugnant, and there are no Mother of the Year awards that go around to anybody on this one. But we have to look at the
Including
person.
Deontae's mother.
Oh, well, okay. Well,
No
Judge,
Mother of the Year award. None.
Okay, Judge. But I'm saying as far as the actual criminality is involved in this, and the mens rea, the kidnapping, the little boy was not in distress. It's the testimony, if you believe the testimony of Cedric Bell, which would be different from his statement, and I guess anything else, but his testimony is she comes to the house, Miss Roberts not. The young boy is not tied up. She didn't say he had to stay there. She was the polite one. Then the interaction is with Mr. Walker. Judge, if I'm merely present with someone that does something horrendous, it shouldn't fall on me. I can't stop, unfortunately, what happened. And if she's in the car, she did not know, based on her interview, that the little boy was dead. She was in the back, in the front seat. She was in the front, yes, ma'am. And she was driving.
Detective Russell's testimony was that Miss Roberts said that she didn't believe that the boy was alive.
Afterward, yeah, but that was after, Judge. That was after the interview in Ohio.
And that was after she saw Mr. Walker choking that boy. She did not believe that he was alive. And in reading her testimony, she had a Freudian slip where she accidentally said that the boy was there. They were near Van Dyke and Harper, and then she tried to go back and clean it up, and it was just too late. And then ultimately she started off saying she didn't know where the boy was. She flipped and said Van Dyke and Harper, and then later, after denying that she didn't know, then she came and gave another place. I think it was Chalmers and Van Dyke, where the boy was, which ultimately he was found in that area.
Well, Judge, I understand that, but I'm not the killer. I'm not the killer.
What it says to me is that Ms. Roberts was there when that child was choked. Ms. Roberts was there when that child was dumped in that field like a piece of garbage. Your client was there.
Yes,
she was
ma'am.
there. And let me tell you the other things that lead me to believe, based on the testimony that's been on this record. First of all, Ms. Roberts knew that that child had been accused of stealing money from her boyfriend. Ms. Roberts knew what her boyfriend was capable of.
Well,
I have no doubt about that. She knew what he was capable of doing. It was Ms. Roberts who got in that car on more than one occasion with Deontae in that car, including when she went to Cedric Bell's home and she knocked on that door and she asked for, I think it's Javion, and Mr. Walker got out of that car and said, "You better tell Javion to bring me my money or I'm going to put a bullet in him, and I already have his friend." She knew then what her boyfriend was capable of doing, capable of putting a bullet in somebody over $70 or $80. And in her own words, they spend that kind of money on liquor all the time. So she did know. Also, she testified in her statement, Miss Roberts, I'm sorry, what's her last name?
It's Roberts.
It's Roberts. She testified in her statement, and I'm telling you all, if you scream out in my courtroom today, I am going to lock you up. I don't care who you are. I am going to lock you up. You can't do it in my courtroom. If you can't contain yourself, please leave the courtroom. While you can leave as a free man or a free woman, because it's not going to look good for you. And I'm going on vacation Thursday. I won't be back here until Monday, and I won't deal with you until Monday. Ms. Diallo, there was testimony from your client that they not from your client, but that your client was there when that child was with the belt, when someone was slapping him in the face, when someone was hitting him in the head, and when Mr. Walker was choking him. And the thing that strikes me is she did nothing. Never called the police, never reported it. She lied. She told so many stories. I don't know if you had an opportunity. I'm sure you did. You read. She told at least 3 iterations of what happened with that child, down to the point where she was trying to protect herself, protect her son, protect her boyfriend, but not one time did she do anything to protect Deontae. She was there. She was a part of it. And then her actions even go on further, where she left Detroit with this monster, with this man, and she went to Toledo. She used her uncle's ID. She knew what had happened. She knew that that child was there. She knew where he had been dumped. And she went to Toledo and she hid with Mr. Walker. She was in it. She was a part of it. Whether she masterminded it or not, she knew what was going to happen. She knew what Mr. Walker was capable of doing. And so I am binding her over as charged. Her arraignment on the information will be July 26, 2016 at 9 o'clock, and she is remanded.
Okay, Judge, I'm sorry, just so the record is clear, we're relying upon the testimony that was gathered and what Ms. Roberts knew. Or are you saying she knew or she should have known?
She knew and she should have known.
Thank you so much, Judge.
Absolutely.
Thank you.
You're very welcome. You may remove that woman from my courtroom. Thank you so much. Mr. Daly?
Yes.
Hold on one second. We're old.
Oh, there you are.
Thank you.
As to your client, Mr. Daly.
Thank you. Let me start with count 2, which is the felony murder.
Yeah.
And the underlying felony is unlawful imprisonment. So if we go back to People v. Aaron at 409 Michigan 672, where the Michigan Supreme Court decided in 1980, just a few years after I became a lawyer, that the intent to commit the underlying felony is not enough for felony murder. So they have to show that Mr. Coleman himself had the intent to murder, first, and secondly, that he did an act, or aided and abetted in an act, that caused the death of the boy. So showing that he may have been involved in an unlawful imprisonment cannot be the evidence that you use to establish an intent to murder. So each individual defendant who's charged separately with felony murder, they have to show an intent to murder, and that the murder occurred in the perpetration or attempt to perpetrate that felony. So if we look at the evidence with regards to Mr. Coleman, we're talking about the testimony of John Reed, Anthony Young, and Ms. Grady, plus Mr. Coleman's statement. And all of that evidence is consistent with what Mr. Surma has admitted, which is that Mr. Coleman was not only not present when the boy was killed, didn't know how the boy was killed. And that when you get down to it, what he did was only to drive the vehicle. It is consistent with all of the evidence that he never did anything to the child, never touched the child, never struck the child in any way, shape, or form. So, for the unlawful imprisonment, they have to show that there was restraint by Mr. Coleman by the means of a weapon or dangerous instrument. I suspect that they're going to say that that was the gun. And then you have obviously a problem, because the only witness who says anything about Mr. Coleman having a gun, and it's contradicted not only by Mr. Coleman, Mr. Reed, and Mr. Young, is that Ms. Grady, when asked for the first time,
Ms. Grady?
Grady, it's G-R-E-A-D-Y, Grady, Grady.
It's misspelled in some of the documents.
Oh, that's why I'm saying Greedy.
Her name is spelled Grady.
Okay. Well, I apologize because on some of the statements there's an E in it.
I just wanted to make sure I was following you, counsel.
Thank you. When Mr. Surma asked her for the very first time, who did she give the gun to? She says Lillian Roberts, right? And then she's impeached. She is impeached by the prosecution. And then we get back to asking her who she gave the gun to and where she was sitting, and it makes absolutely no sense. That where she's sitting in the back seat, next to Mr. Walker, next to Lillian Roberts, that she would take the gun and reach over and hand it to somebody she doesn't even know who he is. I mean, she's totally confused about it, her relationship with him. But I think it's equally clear that she has some relationship with Lillian Roberts. She's at the house, Lillian Roberts' house, all day. So, logically speaking, and putting together all the pieces, it's clear, I think, that Mr. Coleman never had a gun. And when they ask him, of course, that, he says he didn't. So that's really the felony murder. It would be virtually unjust, unfair, to charge and send him to trial on a case where he doesn't have the intent to murder, he's not present, and has nothing to do with the murder itself. That occurred some other time. What they said is that when they got back to the Manistique house, Mr. Coleman was drunk. He had drank a pint of liquor. He went into the house. The boy was still alive. He goes to sleep. He oversleeps the next day. They wake him up. He's late for work. And then he finds out later there's a problem. So I would move that you dismiss count 2. The kidnapping, as Mr. Surma said, the theory is that he's being held for ransom or reward. There's nothing really in the record that says Mr. Coleman did hold the boy in any way, shape, or form. I assume that the prosecutor's theory is that by him driving, that's aiding and abetting in the kidnapping. But I would say you'd have to do more than that to show that he had the necessary intent to kidnap the boy himself. I've already talked about the unlawful imprisonment. The torture in this case, again, under the theory of aiding and abetting, they still have to show that it was also Mr. Coleman's intent that the boy be tortured, even under a theory of aiding and abetting. And they haven't shown that. In fact, what the evidence is in Mr. Coleman's statement is that he was having a heart-to-heart talk to the boy, trying to convince the boy that he should do what Mr. Walker was trying to get him to do. Judge, I'd also ask that you dismiss the felony firearm and the felon in possession based on the argument that I gave with regards to Ms. Grady's testimony that it's not compelling. I mean, essentially what's interesting is in People v. Burrell, which is the seminal aiding and abetting case, Mr. Burrell was the driver of a vehicle. And in the back seat of that vehicle, the co-defendant was having his way with a woman. And the court said that him being in the front seat driving the vehicle without some additional information that showed the defendant's intent, that he could not be convicted as an aider and abetter, and that's exactly what you have here, Judge. I would move to dismiss. If you want me to address any questions or comments that you have, I'd be willing to do that, Judge.
Nope, I'm going to let Mr. Surma respond.
As to the Burrell case, the specific crime was a sexual assault, which was the basis for the felony murder or the aiding and abetting charge. And I think that court realized that driving a car isn't necessary to aid in a sexual assault. But here, holding this young man captive, particularly for the length of time that he was held captive, Mr. Walker needed a driver. Or if he didn't need a driver, it certainly helped to have one. You could consider something like the transport of prisoners in a court setting, when a deputy may be taking a prisoner from one location to another, specifically in a vehicle, and especially if it's a long trip. It could be done with one person, one deputy, but that deputy is going to be a lot safer, and the job's going to be a lot easier if you have 2 or 3 along with you to help keep your prisoner captive. And that's exactly the aid that Mr. Coleman was providing here. The act that's likely to cause great bodily harm or death is not the act of the choking itself,
because I'll concede that the record is, there's no evidence on the record of where Mr. Coleman was at the time Deontae was actually killed. But the act we're asking the court to rely on is, again, not the choking, but the fact that he's driving the car while there's a child being held captive, that the captivity goes on for, I'm saying 5 hours from the very beginning, where the timestamp shows at that store. And again, we don't know if Mr. Coleman was there or not at that time. But we do know that within a very short period of time, he's in the car after they returned to the house on Manistique. So if it's not 5 hours that Coleman's participating, it's very close to 5 hours.
Mr. Sherman, I need you to tell me where in this record, and I know we've had a lot of testimony, and I've gone through every single piece of paper that you all have given me, as well as my notes. Tell me how you're connecting Mr. Coleman to the actual homicide, felony murder. I know the testimony is that, and now I'm not painting him out to be a saint in this at all, because when I read his transcript, he clearly started off not telling the truth, Mr. Davis. He clearly started off not telling the truth, or he told pieces of the truth, and then he left out some things in an attempt to protect his mother and to protect himself. And so he left out some things. I will indicate that when the investigator or whoever was interrogating Mr. Coleman would bring up some things, that then he would attempt to come clean or to tell the truth. Where I'm not clear in this record, and I need you to tell me, is it appears that at some point Mr. Coleman was dropped back off to a house. He was intoxicated, or he had been drinking, and he indicated that he had to go to work the next morning. And so his actions were such that once he was dropped off to that house, he went to sleep. He got up the next day, getting ready to go to work with his normal daily routine, as normal as it can be. And then people started showing him the news feeds and the pictures and his child's mother and his girlfriend, who found out he was messing around with another girl on his job, and went through his phone. And so now there's a whole string of events that lead him to, okay, something went terribly wrong after I was dropped off. So I need to know if I'm missing something that connects him to that murder.
No.
I believe the people have connected him as far as the kidnapping. I applaud Mr. Coleman, although Mr. Coleman never called the police. Never, when he saw the little boy tied up, never called the police. I applaud him. I believe you. I believe in his statement when he said that he was talking to the little boy heart to heart. Why are you out in the street at 13 years old? Why are you out here panhandling and hustling? There are people out here that don't care about you. I believe that all took place. So, but still, notwithstanding that, Mr. Coleman had knowledge that this little boy had been accused of stealing money, and that he was not free to leave, and that this little boy wanted to go home. And yet he drove him from place to place with Mr. Walker in the car, with his mother in the car, with his cousin, or what's the young man's name? I refuse to call him Anthony Young, and with Tamara, at some point, Tamara Grady. But I don't have the nexus for at least not yet, for the torture, for the homicide, felony, murder. So help me out.
So the nexus, if you look at it in the sense that he has to be present at the time that Deontae is killed, then the nexus isn't there. There's no evidence on the record that
even if you can tell me that he knew that in taking this child from place to place, that ultimately the end result would be or could be the child's death.
I think the record is clear on that. Here's some of the things from my notes of Mr. Coleman's interview. On page 10, line 14, he knew defendant number 1 had a gun. On page 11, he's talking to the officer about his participation in questioning Deontae. I asked where he lived.
But Mr. Surma, how did he know he had that gun?
He saw it.
He knew that Mr. Walker had a gun, and he also saw something that someone showed him on television where there was a clipping of Mr. Walker brandishing that gun at a store. But now, when you look at his interview, there's nothing in that interview that said Mr. Walker brandished that gun or had that child at gunpoint. And if I'm missing it, please correct me, because I have read and read and reread.
When, if you look on page 39 at line 16.
Hold on, give me a second. I'm sorry, page.
Page 39.
I'm there at line 16.
Detective Mason asks him, when he showed up with the little boy, did he have a gun? Did Greg have a gun? And Mr. Coleman responds, he had it out, put it in his pocket, and that's when he was telling us what happened. What color was it? Silver.
Yes.
So from the very start, when Mr. Coleman first meets Deontae and first sees that Deontae is being held captive by Greg Walker, he knows that he's armed with a silver pistol.
But you do agree with Mr. Sermon where that is in this transcript, that there's nothing that said, I was looking for where he was holding this child, Mr. Coleman observed Mr. Walker holding this child at gunpoint. I know that there was a gun there. I mean, you all showed me the clip or the video, but that particular line that he had it out, no one followed up as to what was he doing with this gun. And throughout this interview, Mr. Coleman said that he believed, which I don't believe him, that the child was free to leave. The child wasn't free to leave. Even if the gun was in the pocket, the child wasn't free to leave. If the medical examiner's report had indicated that this child had been shot or that he was killed in that way, I need you to connect it for me.
Sure. There's no evidence that the gun was pointed at Deontae. There's no evidence that anyone directly threatened him with it in the sense of pointing the gun up to his head in a classical sense of, this is a threat, you better not run. But when the man takes him at gunpoint from the party store, okay, at that point Deontae knows that he's being held at gunpoint.
Yeah.
Now the gun can go into the pocket. Now when Mr. Coleman first sees it, or admits that he first sees it, Mr. Walker just has the gun out. But it's in the presence of Deontae. And so the presence of that gun is playing a role. If Deontae at 13 is thinking, can I jump out of the car here? Can I escape here? Is now a good time to get away? At any time during those 5 hours, does he want to try to flee or make a run for it? The presence of that gun and his knowledge that one of his captors is armed with the gun certainly has an influence on him and is helping to keep him captive. And Mr. Coleman knows that. Mr. Coleman knows it. The nexus that you're asking me to point out, in the sense that, was Mr. Coleman present when Deontae was choked to death? We don't have that answer. It's not on the record. There's no evidence that I can point to that says he was there when Deontae died. What I can point to is that in the hours leading up to the death, he's participating in what's really an interrogation of the child, trying to find out where he lives, trying to find out where they can take him to get that money back. He's questioning the child while Gregory's hitting him in the head, in his words, a bunch of times. He's questioning that child while Mr. Walker is tying him up by the hands and the legs. His own words on page 86, line 5. While I was talking to the little boy, he tied up his legs. That's when I was talking to him. What did you see Greg do? Smack him upside the head. His own admission that there were times when Greg gets out of the car and Ernest is alone with the child inside the car. Deontae's not going to remain a captive unless Ernest is there playing that role. He's a sidekick. He's a participant, and he's aiding in every sense of, as you said, the kidnapping. But the torture can't go on without him there either. The intentional infliction of emotional stress is going to be greater when there's 3 people present as opposed to 1 or 2. And while he's driving the car, Greg can do the things that he's doing to scare that little boy, to inflict emotional distress on that little boy and to threaten him, and to make him feel that there was a likelihood that he could be killed. The thing I have to ask the court to do is to make this conclusion. In Ernest Coleman's mind, were those actions likely to cause great bodily harm or death? So in Ernest Coleman's mind, when he's driving that car and the boy's being smacked in the head, his hands and legs are being bound, he knows there's a gun present, and he sees the little boy being choked to the point of gasping and choking and fighting for air. In Ernest Coleman's mind, are those acts likely to cause great bodily harm or death? I'd ask the court to, if you say yes to that question, then you have probable cause to bind him over on felony murder and also torture.
Okay.
And the one case, the one unpublished case I've cited for you is some case law that shows that the defendant need not be present at the very time that the death occurs.
Okay, thank you. I'm not going to have you speak again. I'm ready to make my ruling. As to count 2, the homicide, felony murder, I am, for the reasons that I've already stated on this record and the pointed questions that I've asked the prosecutor, I'm going to find that the people have not met their burden. I'm dismissing count 2 as to Mr. Coleman. However, I am going to bind Mr. Coleman over on count 3, the kidnapping on an aiding and abetting theory, as well as count 1 of the charge that it's going to all be consolidated. But I am binding him over on the kidnapping because he knew that that child had been taken against his will and drove that car from place to place. You can't do it. You should have called the police, should have brought him to the police station. You didn't do that. I'm binding you over on the kidnapping. With respect to the torture, there is testimony on this record that in your interview where you indicate, Mr. Coleman indicates that he saw Mr. Walker hitting the boy upside the head. You're driving the boy around. He's not free to leave. Somebody's striking him upside the head. Although Mr. Coleman says in his interview that the little boy was not crying, I don't believe you. I believe that he was crying, that he was asking to go home. I believe that he was looking to you to hopefully help him because you seem sincere in having that heart-to-heart conversation with him, but you didn't do that. And so I'm binding you over on the torture charge as well as on count 5, the unlawful imprisonment. I'm also going to bind Mr. Coleman over on count 6 on the aiding and abetting theory as to the weapons, felony, firearm, and count 9. The weapons, firearms, possession by a felon, aiding and abetting theory, you knew the gun was there, you knew that the defendant, Mr. Walker, had the gun, and so I'm binding you over on those matters only, and the arraignment on the information will be July 26, 2016 at 9:00 a.m. Anything else, Mr. Daly, with respect to Mr. Coleman?
No, thank you.
Okay, you may remove him from my courtroom. Okay, Mr. Castle.
Thank you, Judge.
Make this real brief.
I will try, Judge. I do have some arguments that I don't think
Go right ahead.
presented to the court.
Take all the time you need.
Thank you, Judge. Judge, what I'll tell you is with a number of these counts, I'm just going to leave it to the court's discretion. However, I'd first like to address what I suppose is going to be consolidated with everybody, but count 1 with respect to first-degree premeditated with Mr. Walker. Now, what I'll say is that Mr. Surma's argument, it sounded like certainly, hinged heavily on my client's statement to his probation officer. And what I'll say...
I'm not even going to consider that statement. Go ahead.
Okay. Well, what I'll say, Judge, well, be that as it may, just to make a record, Judge, what I'll say is that in that statement, on a number of instances, Mr. Walker indicates that what happened was in fact an accident. And what I will indicate is also that what is certainly not a good reason for many of the witnesses and even some of the co-defendants' actions were that when questioned either by Mr. Surma or by myself or one of the co-counsel or even this court, when asked, why didn't you call the police to Mr. Bell? Why didn't you, well, not Mr. Bell, I'm sorry, Mr. Young or Mr. Walker, why didn't you call the police? Nobody thought that my client would be involved in anything like this. And certainly, Judge, the allegations in this case are, quite frankly, horrendous. My youthful appearance belays it, but I've seen a lot, and this is up there, Judge. But I think what we have to do is try and disassociate the emotion and the guttural reaction of the facts to the law. And I think that my client's, I know the court said it's not going to take it into consideration, but at least my client's statement to his probation officer or to the interviewing probation agent was that this was not intentional. The people that know my client indicated that they did not think that he would be involved in something of this nature. I don't think there's been anything on the record that this was part of a grander scheme or plan. In fact, Judge, maybe the only thing that's been consistent throughout the testimony of all the witnesses, you know, certain people's testimony changed about who did what, who had what gun, who went where, who said what, who stopped, who got out. The only thing that was consistent is that during this time that Mr. Walker and these other individuals were driving around with this young man, not with the intention to cause him distress, not with the intention to injure him, not with the intention to do anything other than to take him home to his family. Now, I'm not saying that the intent was to take him home to his family because they were being good citizens, Judge. I think the intent was to take him home to his family to probably see if there was some punishment that was going to befall this young man, because as my client clearly suspected and as his friend testified, they did take money from him. They took money that he dropped.
So he tied him up?
I'm not saying any of that is excusable.
Struck him in the head?
I'm not excusing...
Choked him?
I'm not excusing any of that, Judge. Any of that. What I'm saying is that what is clear is that during this entire time, the intention was for this young man to have been brought home, and so obviously that did not work out, and it's incredibly unfortunate that it didn't. But I don't think that the prosecutor has proved that this was a premeditated act that caused this young man's death. So for that reason, for that count, I'm going to ask the court not find over. With respect to the felony murder, I'll leave it to the court's discretion. With respect to the kidnapping, Judge, I think that is probably the biggest weak point for the prosecution, because as they've said, I know, what they've said is that they're going on this theory that this young man was held for ransom or reward. I don't think anybody has said that my client was looking for a reward, and Judge, I don't think there's anything that says he was holding him for ransom.
He wanted the money. He said it.
That's
when he went to Mr. Cedric Bell's house and took his girlfriend to Mr. Cedric Bell's house. He got out of that car and said, tell him I want the money. Tell Javion he better get me my money or I'm going to put a bullet in him. So yes, he was holding Deontae, and he went further to say, I have his friend. Any reasonable mind would conclude that he had Deontae and he wanted his money. And that was the term and condition upon which he would release Deontae.
And I totally agree with that, Judge, but here's the issue. And I think we're both on the same page that reward is not an issue. The issue is one of ransom. And Judge, I think the issue is that, I think first of all, the issue, Judge, is that in much like a claim of right, okay, much like it is, not a legal possibility for someone to steal, I shouldn't say it's not a legal possibility, but much like if Mr. Surma took my phone and then I snatched it back from him, that wouldn't be larceny from a person, because that is my phone. And I think there's no question, Judge, that Javion, the young man who testified a few weeks ago, he indicated that both he and Deontae did in fact take this money. It did in fact belong to Mr. Walker, and so he was in fact looking for property that was his. That's not a ransom, Judge. That's not, hey, in an awfully written note, we got your whoever, we want $1 million. This is my client taking this young man, trying to find his parents, and Judge, for whatever reason, I don't think even the prosecutor would disagree. Every witness who's testified said that these people were driving around for an extended period of time. They made a number of stops. They were looking for this young man's parents. And I know the court's already made comment on that. They stopped at a number of places. They knocked on doors. They, yelled at people. They're trying to find where this...
But Mr. Kessel, that was not the proper response. If someone had stolen something from this man, he should have called the police. He should have reported it. You don't get to be a vigilante and go out there and capture the person who you believe has taken your property and then tie them up, drive them around, beat them up, choke them, and dump them. You don't get to do it. What do we need the police for? We don't. I don't care if it was his money. At the point that his money was stolen, his only right, the only thing that he could have legally done was to report the crime to the police and allow the police to do their job. He didn't do that.
And I certainly understand that, Judge. And I guess the only thing that I would analogize, and obviously it's a much more toned down analogy of this, but is, for example, if this young man's parents would have been at the store. Okay, let's say they had been at the store.
Which I don't understand why they weren't, because he was 13 years old and out at night, and I just wish that the people could charge a whole lot of folks. I have a whole list of people that need to be charged, from failure to take care of your kids, properly supervise your kids, to just being plain, I'm not going to use that word. Go ahead.
I understand, Judge. Let's just say, for example, that this young man's parents had been at the store, and my client had grabbed him and literally physically dragged him over to the parents, okay, and said, hey, your son stole my $80. I want my $80 back. What are you going to do about it? I think obviously that would be a very different scenario for a number of reasons, but in that instance, no one would be saying kidnapping, no one would be saying unlawful imprisonment. Obviously, again, the facts are different, but when this young man has taken my client's money and he's attempting to take him to his parents, which, whatever the circumstances, it clearly seems to indicate he was trying to do, there was no asking for ransom, there was no asking for a reward. So based on that, Judge, I would say that the prosecution has not met the elements of kidnapping, at least certainly for ransom or reward. And finally, Judge, on the torture count, torture is obviously a specific intent crime. And again, Judge, I would say that there's no question that these people were driving around for a long time. There's no question, again, based on the evidence that we've heard, that everyone that they talked to were trying to find where he lives. We're trying to find where his parents live. The witnesses, one after another, would say, when they talked to this young man, and again, we'll leave out the fact that they didn't call the police. When they talked to this young man, they would say, just tell him where you live, just tell him where you live. And whether or not my client was wrong, or these other individuals were wrong in recognizing that at some point he may have given them the correct address. Maybe he didn't even know where his parents were. But they were being driven around, he was being driven around specifically, not for the specific intent to cause him great physical harm. Judge, other than the injuries sustained that caused death, the injuries were actually fairly minimal. The ME's report said there was a bruise on the side of his face. I believe there was one abrasion on his chin, maybe a small one on his elbow, and I think that was it, Judge. So I don't think that even if the young man was smacked and he was hit, that is not extreme physical injury. And so I think what the prosecutor, I see the court looks like it wants to jump in.
No.
Okay, thank you.
I'm going to let you make your record.
Thank you.
River.
The only issue would be if the specific intent was to cause serious mental anguish, Judge. It's not what happened, it's what was the intent. And again, as the record is replete with, there are so many instances of people saying, they're trying to take him home, they're trying to take him home. Whether or not that was the lawful way, the correct way, the vigilante way, the incredibly stupid way, the point is that the intent was to get this young man home, probably for no other reason than to have him get a whooping from his parents and to see if he could get the money back. But there was no specific intent to cause this young man, whether or not it happened, there was no...
What's the intent when you're choking a 13-year-old and you're a grown man? What's the intent?
I would say, Judge, the appropriate...
Just want to scare him? Go put on gloves, go get some rope, you tie him up. Counsel, go ahead.
Thank you, Judge. I'm certainly not excusing those allegations. I'm just simply saying that I don't think there was any evidence that the intention was to cause severe mental anguish. That may have been the case, but that was not my client's intent. Thank you.
Okay, thank you, Mr. Sherman. It's your motion, and then I'm ready to make my ruling. Anything else?
No.
Okay, thank you. Based on the testimony that I've heard on the record from all of the witnesses, some of them whom certainly I believe should be charged, and some who didn't testify that I believe should be charged, it's very clear to this court that Mr. Walker intended to harm that child, he kidnapped that child, he tortured that child, he ultimately caused that child's death, and he dumped that child in a field as if he was garbage. This court is certain, by a probable cause standard and more, that the defendant should be bound over, and therefore he is bound over to the Wayne County 3rd Circuit Court. The arraignment on the information will be July 26, 2016 at 9 o'clock a.m., and he is remanded. If nothing else, on behalf of either parties, thank you.
Thank you, Judge. Thank you, Judge.
Judge, could we collect those exhibits that we had entered, the
Yes, you can
transcripts?
get the exhibits, and I don't know if you may need these transcripts back. No, we might not need to get these transcripts back. I might go through
Yeah.